Welcome to DRTSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab. Hello and a warm welcome to another edition of Supreme Court Judicial Activism to Save Democracy from Corruption, Corrupt Methods of Electing Public Representatives. The other day, it has given a fair judgment on electoral bonds. Why, as a voter and as a citizen, I should not know who is funding and how much, and how the ruling fraternity, everyone reacted, They say they are trying to reduce black money. No, Supreme Court was very categorical and clear. Where is the need for you to hide? Why should you hide? Who are those corporates? What is that money? Why are they paying you such money? Are they doing legal business or illegal business? To support a political party, if they are using illegal money, that means around they will get those representatives whom they need elected. That party will come to power and they will take care of those illegalities which will never come to the fore, as resources are looted in favor of 2 or 3 corporates. Resources belong to every citizen. In doing so, there will never be free and fair election. It was only 2 or 3 corporates funding one party or a set of representatives. So that is the reason why Supreme Court said, what is that money? Who is funding? Why should you have such secrecy? Yes, we have done a show with Ravichandraji, but there was certain things, some individuals who maybe he is an employee, if he is funding in a small amounts, and that too through KYC to the bank or all, his identity should be kept in because he is an employee. If he is funding an opposition party, the party in power may victimize him. For that matter, that is understood. But corporates, huge money, and all those funds which are coming into the political parties in the form of electoral bond, who are they? So such a vital judgment to save people participatory constitutional democracy vis-a-vis free and fair elections, so that every party or individuals or independents will have the main stake. But unfortunately, there is another judgment which Hyderabad High Court has upheld, and that we will come back later in the course of things. We will discuss that. And subsequently, immediately the very next day or 2 days later, it has nullified the election in Chandigarh mayor poll, wherein the same methods were adopted, illegal methods by the officer there, trying to see that the party, BJP party mayor wins by marking 8 ballots. So Supreme Court again came to the rescue of people participatory constitutional democracy, wherein it made them to count those 8 votes. In doing so, Aam Aadmi Party and Congress-sponsored candidate won the election. So a good day for democracy. We are not here to criticize one party or favor the other party, but we want free and fair elections. There should be transparent and absolute accountability. And at the same time, every citizen of this wonderful country should know what is happening. Only then he will understand and then he will vote. That is why 19(1)(a) is so crucial. Information. For me, I need information about the political parties in toto and the candidates in toto. But here in Dharani also, they were trying to have that secret column wherein you need not reveal. That is absolute nonsense. So this is how there are some black taints. Now, yesterday, on 4th, Supreme Court came out with another wonderful judgment. This is as far as electoral bonds, free and fair elections, where you go and vote, party funding, and then the role of election officer, how he was tainting, to see that these are all malpractices in defeating free and fair elections. Now the other one, wherein MLCs or other or Rajya Sabha MPs, they have taken a case of JMM bribery case, PV Narasimha Rao case, wherein that immunity which was there for MLAs, MPs, that has been taken off. If they are indulging in bribery or corrupt deals or activities in getting someone elected. And that is why the case cash for vote wherein the present chief minister, he was in TDP then, Mr. Revanth Reddy, in getting another MLC for TDP to be elected, wherein he has been caught with that 50 lakhs. Which money is that? Whose money is that? There were different names, and he was speaking to someone, and see, they said, Chandrababu Naidu, what happened to that voice which they have sent to forensic for Chandigarh? Why KCR government or his family members kept quiet till this day? When they were in ruling, they never bothered to open that case. But ED had gone through all the trail, 50 lakhs, it said clear-cut money. And whose money is that? That is where everything starts. So these corrupt practices no more will have immunity for MLAs and MPs. That is why the Honorable Chief Minister Revant Reddy's case in Supreme Court, after this order, becomes more and more interesting. We are not here to judge anyone, believe me. Till proved, no one is guilty. The trial is going on, and even those who are watching, they wanted the case to be shifted to Madhya Pradesh because Revant Reddy has become the chief minister and he himself is the home minister. But why only Madhya Pradesh? They could have gone to other states. Fine, I leave it because Madhya Pradesh is again ruled by BJP. And in doing so, this Supreme Court order has been welcomed by Honorable Prime Minister, who is still in Telangana touring. And both after that also, Prime Minister Modi and Revant Reddy attended, unveiling some wonderful programs for Telangana. We don't know, everything is on paper. Till we understand and dissect, then we will understand the true nature of those. But we welcome. Did he speak? What did he speak? Is it the same Banhumi like KCR after he has been caught through Kaleshwaram, Palamur Rangareddy lift irrigation, Mission Bhagirath, the same thing, that type of Banhumi? Is it expected post the Supreme Court order? If that is the case, don't you think it will be detrimental to the people of Telangana who have already suffered for 10 years for this corrupt regime, anti-democratic regime? They did not allow protests, cases. Central government was happily enjoying it. They said their protection money has gone, whether it is Kaleshwaram, Palamur, Rangareddy lift irrigation scheme. As and when it comes in the Supreme Court, it doesn't go beyond. So that is why many doubts are there regarding central government. So many raids happened, right from Mega and out. What happened to those raids? Nothing comes out. That is the reason why this show is very, very important when it comes to, again, a free and fair election. Whether it is you go and vote or whether it is the tainted election officers who are supposed to be neutral and independent and judiciously counting the votes, not tampering with the ballot papers, or those we elect in a free and fair election, those MLAs have to elect MLCs as well as Rajya Sabha MPs under MLAs quota. So, is that election free and fair? That PV Narasimha Rao, JMM bribery case, you all know, 1998 judgment in lieu of 1988 Prevention of Corruption Act. That has been struck down, stating there is no immunity for all those MLAs or MPs or tainted, even when MPs were trying to bribe to see that the government or the day of the government survives or to get them elected to the respective legislature bodies. Let me show you to start with. As usual, first I'll try to share what is this judgment all about. Then we'll go to corruption and bribery of MPs and MLAs erode foundation of Indian parliamentary democracy, Supreme Court. The latest verdict, setting aside the earlier ruling, was handed out by a 7-judge constitutional bench of Chief Justice of India, D.Y. Chandrachud and Justice A.S. Bopanna, Justice M.M. Sundaresh, Justice P.S. Narasimha, Justice J.P. Pardiwala, Justice Sanjay Kumar, and Justice Manoj Mishra. Wonderful. Hats off to you. Now let us listen.
94 of the Constitution. A member of Parliament or the Legislative Assembly, as the case may be, can claim immunity from prosecution on a charge of bribery in a criminal court. We disagree with and overrule the judgment of the majority on this aspect, our conclusions are thus. 1. The doctrine of stare decisis is not an inflexible rule of law. A larger bench of this court may reconsider a previous decision in appropriate cases, bearing in mind the tests which have been formulated in the precedents of this court. The judgment of the majority in P.V. Narasimha Rao, which grants immunity from prosecution to a member of the legislature who has allegedly engaged in bribery for casting a vote or speaking, has wide ramifications on public interest, probity in public life, and parliamentary democracy. There is a grave danger of this court allowing an error to be perpetuated if the decision were not reconsidered. 2. Unlike the House of Commons in the UK, India does not have ancient and undoubted privileges which were vested after a struggle between Parliament and the King. Privileges in pre-independence India were governed by statute in the face of a reluctant colonial government. The statutory privilege transitioned to a constitutional privilege after the commencement of the Constitution. 3. Whether a claim to privilege in a particular case conforms to the parameters of the Constitution is amenable to judicial review. 4. An individual member of the legislature cannot assert a claim of privilege to seek immunity under Articles 105 and 194 from prosecution on a charge of bribery in connection with a vote or speech in the legislature. Such a claim to immunity fails to fulfill the twofold test that the claim is tethered to the collective functioning of the House and that it is necessary to the discharge of the essential duties of a legislator. 5. Articles 105 and 194 of the Constitution seek to sustain an environment in which debate and deliberation can take place within the legislature. This purpose is destroyed when a member is induced to vote or speak in a certain manner because of an act of bribery. 6. The expressions anything and any must be read in the context of the accompanying expressions in Articles 105.2 and 194.2. The words in respect of means arising out of or bearing or clear relation to and cannot be interpreted to mean anything which may be even have a remote connection with the speech or vote given. 7. Bribery is not rendered immune under Articles 105.2 and the corresponding provision of Article 194 because a member engaging in bribery commits a crime which is not essential to the casting of the vote or the ability to decide on how the vote should be cast. The same principle applies to bribery in connection with a speech in the House or a committee. 8. Corruption and bribery by members of the legislatures erode probity in public life. 9. The jurisdiction which is exercised by a competent court to prosecute a criminal offense and the authority of the House to take action for a breach of discipline in relation to the acceptance of a bribe by a member of the legislature exist in distinct spheres. The scope, purpose, and consequences of the court exercising jurisdiction in relation to a criminal offense and the authority of the House to discipline its members are different. 10. The potential of misuse against individual members of the legislature is neither enhanced nor diminished by recognizing the jurisdiction of the court to prosecute a member of the legislature who is alleged to have indulged in an act of bribery. 11. The offense of bribery is agnostic to the performance of the agreed action and crystallizes on the exchange of illegal gratification. It does not matter whether the vote is cast in the agreed direction or if the vote is cast at all. The offense of bribery is complete at the point in time when the legislator accepts the bribe. And 12. The interpretation which has been placed on the issue in question in the judgment of the majority in P.V. Narasimha Rao results in a paradoxical outcome where a legislator is conferred with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but eventually decides to vote independently will be prosecuted. Such an interpretation is contrary to the text and purposes of Articles 105 and 194.
Yeah.
Whether by virtue of Articles 105 and 194 of the Constitution, a member of Parliament or the Legislative Assembly, as the case may be, can claim immunity from prosecution on a charge of bribery in a criminal court. We disagree with and overrule the judgment of the majority on this aspect. Our conclusions are thus. 1. The doctrine of stare decisis.
సో ఇది చాలా క్లియర్గా ఉన్నది. ఎవరైతే డబ్బులు తీసుకొని ఓటు వేసినా ఎమ్మెల్యేలు కానీ ఎంపీలు కానీ డబ్బులు తీసుకొని శాసనసభలో కానీ అక్కడ లోక్సభలో కానీ అటువంటి అంశాలు వారు అక్కడ చర్చించిన ఇది అవినీతి. సో దాన్ని ఇంతకుముందు ఎమ్మెల్యేలకు ఎంపీలకు ఆ వెసులుబాటు ఉండేది వారిపై చర్యలు తీసుకోకుండా చట్టరీత్యా. నేరమైనటువంటిది, నేర రూపమైనటువంటి చట్టాలు వారిపై చర్యలు తీసుకోకుండా ఉండేవి. కానీ ఇప్పుడు ఆ చట్టాలు తొలగించారు. ఎవరైతే వీటికి పాల్పడతారో వారికి నేరం ఆపోదించి వారిని కూడా నేరస్తులుగా పరిగణింపవాలి, వారు కూడా శిక్షింపబడవాలి. ఎందుకంటే ఇది ప్రజలు, మన భారతదేశ పౌరులు పాల్గొనేటువంటి ప్రజాస్వామ్యానికే పెద్ద మచ్చ అని వారు చెప్తా ఉన్నారు. మరి తీసుకున్న వారి పట్ల ఇది, మరి ఇచ్చిన వాళ్ళ పట్ల ఇప్పుడు అక్కడ మన రేవంత్ రెడ్డి గారి విషయంలో కవిత మాట్లాడుతూ ఉంది. వారు కూడా ఒకసారి చదువుకోవాలి. ఇప్పుడు ఇక్కడ ఈ జడ్జిమెంట్ ఈ విధంగా ఉంది. తీసుకున్నవారు, మరి ఇచ్చిన వారు, వారి పరిస్థితి ఏందో మరి తన స్టేట్మెంట్ ఇస్తా ఉంది. మరి అది కూడా వారు కనుక్కోవాలి. వారు ఎందుకు ముందుకు పోలేదు, ఎవరు ఇచ్చినారు, ఆ 50 లక్షల డబ్బులు ఎక్కడివి అనేది కూడా మీకు చూపిస్తాను. సో ఈ విధంగా ఈ చట్టాన్ని తీసుకురావడం వల్ల ప్రజాస్వామ్యాన్ని పరిరక్షించలేదు. जो कल एक हमारे सुप्रीम कोर्ट जो फैसला सुनाया है, वो ये कहता है कि पीवी नरसिम्हा राव और जेएमएम के जो भ्रष्टाचार के आरोपण थे कि वहां के जो विधायक हो, शासन सभा के या लोकसभा के, अगर ये लोग किसी तरह भ्रष्टाचार के रूप में पैसे लेके कोई अंश को विधानसभा या लोकसभा में इसका प्रस्तावित अगर किया तो वो कानूनी है। इसके पहले उनको एक नियंत्रित तौर पर था, लेकिन अब ये गैर कानूनी है। उनको भी, एमएलए हो या एमपी हो, उनको भी ये कानून लागू होगा। तो इसका मतलब यह है कि लोकतंत्र को बचाने की एक बड़ी अंश है। जब जो जीत के आते हैं एक सही तरीके के रूप में आना चाहिए, किसी तरह की भ्रष्टाचार और उस तरह के पैसे से अंश विधानसभा हो या लोकसभा में चर्चा नहीं होना चाहिए। तो इसलिए हम पूर्ण सम्मति से जो पीवी नरसिम्हा राव के केस में 1998 में सुप्रीम कोर्ट जिस तरह वो फैसला सुनाया था, उसको आज पारित कर दिया है, खत्म कर दिया है इस जजमेंट से। तो ये है उसका।
And the authority of the House to discipline its.
And then just showing you immunity for lawmakers indulging in bribery. SC-Quashes majority verdict in 1998 JMM bribery case. No immunity for lawmakers indulging in bribery. SC-Quashes majority verdict. The judgment in PV Narasimha Rao has wide ramifications on public interest, probity in public life, and parliamentary democracy. A claim to immunity by the legislator fails to fulfill the twofold test that the claim is tethered to the collective functioning of the House and that it is necessary to the discharge of duties of the legislator, court said. Here. Bribery not protected by legislative privileges. No immunity for MPs, MLAs taking bribe for oath, speech in legislature. So even oath also. In a landmark judgment, the Supreme Court on Monday overturned the 1998 PV Narasimha Rao judgment, which held that members of parliament and legislative assemblies could claim immunity under Articles 105(2) and 194(2) of the Constitution for receiving a bribe in contemplation of a vote or speech in the legislature. The latest verdict, setting aside the earlier ruling, was handed out by a 7-judge Constitution bench of Chief Justice of India, D.Y. Chandrachud, and Justice A.C. Boppana, Justice M.M. Sandresh, Justice P.S. Narasimha and all. So this bribery in Parliament, Justice S.C. Agarwal, Justice Dr. A.S. Anand, Justice S.P. Barucha, Justice Rajendra Babu, Justice G.N. Ray, what did they were the ones who have passed this judgment in PV Narasimha Rao case in 1998. Why did the... So let me just show you. I've already told you. What was the 1998 Narasimha Rao judgment that Supreme Court overruled in cash for votes verdict? That already we have shown you. The Supreme Court overturned a 1998 judgment protecting MPs and MLAs from prosecution for taking bribes in the House. PM Modi praised the decision for promoting clean politics and restoring faith in the system. The Supreme Court has overturned a 1998 judgment protecting MPs and MLAs taking bribes to vote or make a speech in the House, a 7-judge constitutional bench that you are all aware. In the 1998, the 5-judge constitutional bench held in its majority verdict on the Narasimha Rao versus CBI case that parliamentarians have immunity against criminal prosecution for any speech made and vote cast inside the house under Articles 105(2) and 194(2). Okay. So this is it. I hope I'm very clear now. Now how? This is the cartoon which after demonetization, SC strikes down electoral bond scheme, reveal donors details, SC. That was when, and yeah, this is the tweet of Honorable Prime Minister. A great judgment by the Honorable Supreme Court, which will ensure clean politics and deepen people's faith in the system. Wonderful. I only hope you will stand by that. Yesterday, when this judgment came, he was here along with Mr. Revanth Reddy. అభివృద్ధి కోసం వేదికలు పంచుకుంటాం, సంక్షేమంలో సమన్వయంతో పనిచేస్తాం, సమాఖ్య స్ఫూర్తిని గౌరవించడమే మా సిద్ధాంతం, రాష్ట్ర విషయంలో రాజీ పడబోం, ఆత్మగౌరవం విషయంలో తలెత్తుకునే ఉంటాం. They were inaugurating so many programs yesterday. When the judgment came, Honorable Chief Minister, Mr. Revanth Reddy was with Mr. Prime Minister of India. Why I'm showing you is because the cash for vote scam still it's going. Now, flip side, what are the comments? Immediately political heat. Let us. Mind you, she is already in liquor scam and BRS party is tainted with so many allegations against Kaleshwaram, the same BJP government, how ATM and all, Palamur Rangareddy lift irrigation scheme in the Supreme Court. Now she is speaking here.
ఇవాళ ఒక తీర్పు ఇవ్వడం జరిగింది. ఆ తీర్పు ఏంటంటే ఏదైతే ప్రివెన్షన్ ఆఫ్ కరప్షన్ యాక్ట్ ఉంటుందో అది ప్రజాప్రతినిధులకు వర్తిస్తుందా వర్తించదా అనేటటువంటి అంశం మీద ప్రజాప్రతినిధులకు కూడా ఇది వర్తిస్తుంది అని చెప్పి సుప్రీంకోర్టు తీర్పు ఇచ్చింది. దాన్ని ప్రధానమంత్రి గారు ఇందాకనే ట్విట్టర్లో స్వాగతించినారు. ప్రధానమంత్రి గారు స్వాగతించినటువంటి అంశాన్ని మేము కూడా స్వాగతిస్తూ మరి ఈ రాష్ట్రంలో గౌరవ ముఖ్యమంత్రి రేవంత్ రెడ్డి గారు అక్యూజ్డ్ నంబర్ 1గా ఉన్నారు ఓట్ ఫర్ నోట్ కేసులో. ఆ కేసును త్వరితగతిన మరి కేంద్ర ప్రభుత్వం టేకప్ చేసి దాని ప్రివెన్షన్ ఆఫ్ కరప్షన్ యాక్ట్ అప్లై అవుతుంది అనేటటువంటి అంశం సుప్రీంకోర్టు క్లారిటీ ఇచ్చింది కాబట్టి ఆ కేసును తొందరగా టేకప్ చేయాలని చెప్పి ప్రధానమంత్రి గారిని మేము డిమాండ్ చేస్తూ ఉన్నాం. సుప్రీంకోర్టు ఇవాళ ఒక తీర్పు ఇవ్వడం జరిగింది. ఆ తీర్పు ఏంటంటే ఏదైతే ప్రివెన్షన్ ఆఫ్ కరప్షన్ యాక్ట్ ఉంటుందో అది ప్రజాప్రతినిధులకు వర్తిస్తుందా వర్తించదా అనేటటువంటి అంశం మీద ప్రజాప్రతినిధులకు కూడా ఇది వర్తిస్తుంది అని చెప్పి సుప్రీంకోర్టు తీర్పు ఇచ్చింది. దాన్ని ప్రధానమంత్రి గారు ఇందాకనే ట్విట్టర్లో స్వాగతించినారు. ప్రధానమంత్రి గారు స్వాగతించినటువంటి అంశాన్ని మేము కూడా స్వాగతిస్తూ మరి ఈ రాష్ట్రంలో గౌరవ ముఖ్యమంత్రి రేవంత్ రెడ్డి గారు అక్యూజ్డ్ నంబర్ 1గా ఉన్నారు ఓట్ ఫర్ నోట్ కేసులో. ఆ కేసును త్వరితగతిన మరి కేంద్ర ప్రభుత్వం టేకప్ చేసి దాని ప్రివెన్షన్ ఆఫ్ కరప్షన్ యాక్ట్ అప్లై అవుతుంది అనేటటువంటి అంశం సుప్రీంకోర్టు క్లారిటీ ఇచ్చింది కాబట్టి ఆ కేసును తొందరగా టేకప్ చేయాలని చెప్పి ప్రధానమంత్రి గారిని మేము.
ఇది రాజకీయం. వారు కూడా కేడి కవిత గారు వారి ఇంటి పేరు చెప్తా ఉన్నారు, ఎమ్మెల్సీ. వారు లిక్కర్ స్కామ్ రాగానే ఆగ మేఘాల మీద తండ్రి ముఖ్యమంత్రి కాబట్టి వారిని ఎమ్మెల్సీగా చేశారు. ఎందుకంటే ఈ నేరం నుంచి తప్పించుకోవడానికి వారికి ఈ విధమైనటువంటి ఒక భద్రత ఉంటుంది కాబట్టి తను ఇప్పుడు ఏదైతే చెప్తుందో భద్రత. కానీ ఇది పార్లమెంట్లో క్యాష్ ఫర్ ఓట్ ఎవరైతే తీసుకుంటారో లేదా క్యాష్ ఫర్ స్పీచ్ ఏదైతే అంశాన్ని లేబట్టడానికి తీసుకుంటారో అదే అమ్మ కవితమ్మ. సో మీరు అనేది రేవంత్ రెడ్డి గారిది. ఎస్, మీరు ఉన్నప్పుడు ఏం చేశారు రేవంత్ రెడ్డి గారు, మరి మీ విషయంలో ఏమిటి? ప్లస్ కేసీఆర్ గారి విషయంలో, కేటీఆర్ గారి విషయంలో ధరణి కానీ కాళేశ్వరం కానీ ఏమిటి మాట్లాడరా? అది కూడా మీరు చెప్పాల్సిన బాధ్యత ఉంది. స్వాగతిద్దాం మనము క్లీన్ పాలిటిక్స్. వి వాంట్ క్లీన్ పాలిటిక్స్ యాజ్ ప్రైమ్ మినిస్టర్ వాస్ ట్రైయింగ్ టు reiterate. Now we'll go to cash for vote. Cash for vote case. SC issues notice to CM Revanth Reddy on play to transfer trial against him. A bench of Justices B.R. Gavai and Sandeep Mehta sought a response in the matter within 4 weeks of the play by Guntakandla Jagdish Reddy and 3 others. This was on 9th February. Time 4 weeks. So before that, this judgment has come. The Supreme Court on Friday issued notice to Telangana government and its Chief Minister A. Revanth Reddy on a plea to shift the impending trial in 2015 cash for votes against the Congress leader. A bench of Justices B.R. Gavai and Sandeep Mehta sought a response in the matter within 4 weeks on the plea by the Guntla so and so. The plea filed through Advocate P. Mohit Rao sought a direction to transfer the case from Hyderabad to Bhopal, Madhya Pradesh to ensure a free and fair trial because the petitioners include a former Deputy Chief Minister and former ministers of Telangana. Equally, they should also file petitions against Dharani, IL&FS, and what is that KTR link? Same way, Kaleshwaram also, I would really welcome them. The play claim, Reddy, who is the prime accused in 2015 case, has become the Chief and Home Minister for the state of Telangana with 88 criminal cases pending against him. Under these circumstances, as the accused has a direct control over the prosecution, it is understood that there cannot be any possibility for free and fair trial, which is sine qua non of Article 21 of the Constitution. The play said, if the trial is continued by the principal judge for trial cases at Hyderabad, Telangana, then the rule of law will be vitiated and judicial fairness, criminal justice system would be at stake, shaking the confidence of the public at large. So many cases were there against you also, but fine, we are not. Then also we'll see. This is the past. Supreme Court dismisses Revanth Reddy's quash petition in cash for vote case. The October 3rd, the Supreme Court, while dismissing his quash petition of Revanth Reddy on Tuesday, made it clear that the cash for vote case came under the jurisdiction of the ACB, Anti-Corruption Bureau. In a big shock to TPCC President A. Revanth Reddy, the Supreme Court, while dismissing his quash petition on Tuesday, made it clear that the cash for vote case came under the jurisdiction of Anti-Corruption Bureau. Earlier, Revanth Reddy approached the Telangana High Court in connection with the cash for vote case. In his petition, the TPCC President stated that the cash for vote case did not come under the purview of ACB. However, the High Court dismissed the petition and Revanth Reddy approached the Supreme Court and challenged the High Court verdict. He said it's a people's representation. An elected bribe him, another elected to get another one elected. But yesterday's Supreme Court judgment, unanimous judgment, setting aside 1998 PV Narasimha Rao JMM bribery case, how it is going to affect, we do not know. Because here, those who take money, but those who give money, because he is also an elected MLA, MP that time, MLA or MP in TDP, and everything is recorded. So, part of legislature, maybe this new law, we don't want to give him because last time when we gave some middlemen, when said it's People's Representation Act, that is how they got the bail. Middlemen made hundreds of crores. Now we don't want to give them free advices because we want to save people participatory constitutional democracy. Here also there is a glitch. Cash for vote, ED files charge sheet. This is what I'm trying to say. That 50 lakhs money. Whose money is that? TDP's as being claimed in the circles. Is it Chandrababu Naidu money? When it comes to the court, will Revanth Reddy go and say it is this money has been given by Mr. Chandrababu Naidu? At the same go, both individuals will sink. The YSR stakes will start rising, TDP stakes will start falling, and it is a clicks in which this latest judgment has landed. ED filed charge sheet against Telangana Congress working President Revanth Reddy. This is appropriate. Enforcement Directorate on Thursday filed a charge sheet against. This is on. I'm trying to bring it to you. The old one, May 27, 2021. Okay. I'm giving you the just history. On Thursday, filed a charge sheet against Telangana Congress Working President and Lok Sabha MP Revanth Reddy and others in connection with cash for vote scam. The ED has provisionally attached rupees 50 lakh cash offered to Anglo-Indian nominated MLA Elvish Stephenson for voting in favor of Telugu Desam Party candidate. The offence took place on May 31st, 2015. Revanth Reddy was in TDP at the time of the incident. He later joined Congress Party. Reddy is now Malkajgiri MP as well. Now he is the Honorable Chief Minister of Telangana. ED has named Revanth Reddy, TDP, ex-MLC, Vem Narendra Reddy's son, Vem Krishan Kirtan Reddy. Now Vem Narendra Reddy is the advisor. The TDP link is affecting him because in the latest also in GHMC case, we are suspecting a phone call went to GHMC commissioner on the irregularities and illegalities without understanding how they have been occupying public park and how they are trying to forge documents belonging to others' lands, trying to usurp other lands. And how is that the same advisor to CM forgot to even to get into the case? 2016, Deputy Collector Shellingampalli clearly, after the survey, reporting that that land belongs to Mr. Pratap Reddy and it is under 204/2 with clearly defined boundaries. So the same link, it is going to affect Mr. Revant Reddy or others. We are not here to. The money was supplied by Vem Narendra Reddy's son. Why I'm asking, even the GHMC latest case, the same if happens, that will continue, that is going to severely and seriously affect Honorable Chief Minister. The ACB and EDR, however, the agencies failed to get the money trial. The discharge sheet also mentions TDP N. Chandrababu Naidu, but not as an accused. The two agencies, ACB and AD, could not produce any evidence against Naidu. Initially, the case was booked by the Telangana ACB. The ED has filed a money laundering case based on the ACB FIR and charge sheet against Revant Reddy and others. ACB caught Revant Reddy red-handed while he was paying rupees 50 lakh bribe to Elvis. The bribe was offered to vote in favor of TDP candidate Vem Narendra Reddy in the Telangana Legislative Council elections that were held on June 1, 2015. Stevenson accused Revant Reddy of offering 2 crores and a flight ticket to leave the country. The initial payment of rupees 50 lakh was paid and the rest was promised after voting. ACB captured the complete exchange on camera. A phone conversation between Elvis and the TDP chief Naidu, this is important, was also verified by forensic experts and the voice is found to be that of Naidu. See, and why KCR kept quiet all these years? Why BJP kept quiet all these years? Why the CBI or ED kept quiet all these years? This is a mystery. In July 2015, ACB had filed a charge sheet against Revant and others under the Criminal Conspiracy and Prevention of Corruption Act. That's it. So that's what I'm trying to show you all. And we have already shown you everything. So this is it. And we will leave it to the fair judgment of the honorable citizens who themselves are voters. Now this judgment implies that anyone can go and question the MLA or MP in getting their issues settled in a legalized way, because now this is the constitutional right. They cannot take bribe from the others, as we have seen in GHMC Shellingampalli Madinuguda case, and say that we will not help you or not represent your case in the assembly or Lok Sabha when it pertains to policy or when it pertains to that society or that village or whatever it is. They can never try to deny. This applies to mainly opposition, because when opposition MLAs and the ruling party come together, the devastation what has witnessed in Telangana, how BRS and AIMIM coming together has destroyed the faith of democracy, the faith of people in democracy. It was autocratic, undemocratic, lot of corruption, and at the end of the day, it left a surplus state in 2014 into a state which has borrowed more than lakhs of crores of rupees. And where did that money go? Kaleshwaram still not in utility. Palamuru Rangareddy lift irrigation not in utility. And you see Mission Bhagirath and all, COG reports and everything. But this is the fate of a country, a state, if there is no transparency and accountability, and if there is no free and fair election. That is the reason why this judgment is very fundamental, because that ill-gotten money through electoral bonds we have seen. So that same ill-gotten money, if some MLA or MP is utilizing to get the vote of another MLA or MP, and that MLA MP, if he accepts, he will come under the radar of this new Corruption Act. You cannot escape. There is no immunity for you. It is gone. Similarly, if someone, whether it is in the opposition or in the ruling too, if they take money for their speech on the floor of the legislature or in the Lok Sabha, if they are demanding money to raise a specific issue, that also comes under corruption. They will be adequately be probed, they will be put to trial. There is no immunity for them. So 105 and 194 sections, which gave that immunity in PV Narasimha Rao and JMM bribery case, has been struck down, stating there should be probity in public life and parliamentary democracy has to be protected, and that has to survive if India remains to be a people participatory constitutional democracy. प्रजास्वाम्यमा वर्धिल्लु, लोकतंत्र देश बना रहे, भ्रष्टाचार खत्म हो, అవినీతిని పాలద్రోలాల, పారదర్శకత జవాబుదారితనం పాలనలో తేవాలా. అదేవిధంగా శాసనసభలో లోక్సభలో కూడా అదే విధమైనటువంటి పారదర్శకత జవాబుదారితనం, ఎక్కడ అవినీతి లేనటువంటి ఆ చర్చలు జరగాల, ప్రజాహితంలో జరగాల. అప్పుడే ప్రజాహితమైనటువంటి ప్రజాస్వామ్యం బ్రతుకుతుంది అనేది సుప్రీంకోర్టు ఒక మంచి తీర్పు. ఆ తీర్పు వల్ల ఇప్పటికైనా ఎమ్మెల్యేలు కానీ ఎంపీలు కానీ ఇటువంటి వాటికి పాల్పడకుండా, మెజారిటీ అనో అదనో పాల్పడకుండా వారు ప్రజాహితంలో పారదర్శకంగా జవాబుదారితనంతో వారు వ్యవహరిస్తారని, తద్వారా ప్రజాస్వామ్యం బ్రతుకుతుంది అని ఆశిస్తూ, దిస్ ఆర్డర్ will definitely have an insight into all those elected MLAs and MPs, and that probity in life, I only hope they will uphold so that parliamentary democracy survives. And this is a big boon for all of us. We are the constitution. No one can now deny, saying you have voted for this party, you have not voted for me, whether I am going to favor this fellow, this corporate or that corporate will never exist now. Whoever takes money at the cost of the parliamentary democracy, they're all going to be punished legally. There is no immunity. Wonderful, great judgment by Supreme Court, and Prime Minister of India too welcomed it, stating that it will be for clean politics. And the MLC Kavita now raised a banner stating that that should be applicable to Mr. Revant Reddy, who is there in cash for vote, who is the Honorable Chief Minister now, forgetting what is her case, Delhi liquor to Kaleshwaram. That also should be probed independently, because they're all elected representatives indulging in corruption. So there should not be no freebie. And here they have been charge sheeted as by ACB also. An ED trial is also there, and Supreme Court has given 4 weeks on shifting the case from Hyderabad to Bhopal. What will happen in the lieu of this latest judgment striking down the PV Narasimha Rao JMM bribery case? Those who are seeking and those who are trying to create that opportunity of funding, will they also attract? At the same time, whose money that 50 lakhs is? And that forensic call has definitely identified Mr. Chandrababu Naidu. Though they have not registered him as accused, why we don't know. And the voice was very categorical and clear. We will take care of you. Don't worry. You do vote. What is that? Is not a co-conspiracy. In doing so, if this case moves ahead on time, will it going to create ripples in Telangana as well as in Andhra Pradesh political scene? Now Andhra Pradesh is destined to go for elections. Will this be a big tool for YSRCP? Let's wait and watch. Similarly, at the end of the day, union government, when it comes to the CBI or ED, they should allow them to function independently. That is how the parliamentary democracy will survive. The corruption is the scourge of society. Fraud vitiates everything. I only hope these agencies would function independently and probe in all fairness, so that corruption is rooted out, fraud is totally abolished for survival of parliamentary democracy. Thank you very much. Do support DRTSPR channels, Citizen DRTSPR channel, and Environment People DRTSPR channels. They are all in larger public interest only. Anyone can participate. You can differ with me. Wherever you are, I'll connect you. We can debate, but it should be purely on the basis of Constitution, law of the land, invoking Evidential Act, with no enmity against individuals, nor animosity against any parties or organizations. Similarly, do support DRTSPR channels. My mobile number is 944046533, to which PhonePe as well as Google Pay is attached. Thank you very much. Again, I say, Mera Bharat Mahan. And I would definitely say, Jai Telangana and Jai Hind, corruption-free Bharat, Aviniti లేనటువంటి భారతదేశం, Brashtachar Mukt Bharat. That is what we need and we want.